Hello, I'm Eunice Collins, and I will be speaking today on the topic of judicial misconduct and how to define that term. Under the Irish Constitution, Article 35(4), judges of the higher courts can only be removed from office for stated misbehaviour and incapacity. I'll briefly just note that these are not necessarily mutually exclusive. For example, in Australia, in New South Wales, a judge was found to be driving under the influence of alcohol and also suffering from alcoholism. That said, today I'll be focusing on misconduct and misbehaviour. There's no definition of judicial misconduct or misbehaviour in the Constitution, and it has been suggested that the Houses of the Oireachtas could decide by majority what is meant by the term stated misbehaviour. But to my mind, we would also have to bear in mind that these terms have a meaning in themselves, and they could not be interpreted in a way that does violence to the meaning of the terms or that seriously hinders judicial independence in Ireland. Given that there is no constitutional definition of stated misbehaviour, I think it's worth turning to the definition of judicial misconduct in the Judicial Councils Act 2019. And I accept that these are two separate terms, misbehaviour and misconduct. But to my mind, given that there is no definition of misbehaviour in the Constitution, and the potentials for confusion if misbehaviour and misconduct were defined differently, I think it is worth trying to interpret these terms in a manner that's consistent with each other. So if we turn to the Judicial Council Act 2019, judicial misconduct is defined as an act or omission by a judge in execution of his or her office or otherwise, which A, constitutes a departure from acknowledged standards of judicial conduct, and B, brings the administration of justice into disrepute. So that raises the question of what do we mean by acknowledged standards of judicial conduct? And I think it is worth turning to international common law jurisdictions to try to flesh out the meaning of that term. Partly because we don't have that many examples of judicial misconduct in Ireland. I think the only time I could find that a judge had been removed from office was in 1830, when Sir Jonah Barrington was removed for financial irregularities. And secondly, I think the Act itself seems to reflect the Bangalore principles of judicial conduct. If we look at subsection 7(1)(b) of the Act, it refers to judicial independence, impartiality, integrity, propriety, competence, diligence, and ensuring equality of treatment to all persons before the courts. And these principles clearly reflect the Bangalore principles of judicial conduct. So to my mind, that suggests international standards are relevant when defining acknowledged standards of judicial conduct. I'm aware that Professor Ray Byrne, Dr. Brian Barry, and Dr. David Fennelly will be discussing these principles, so I won't dwell too long on them. But I do think that it is worth considering in international examples from other common law jurisdictions when defining what we mean by acknowledged standards of judicial conduct. So if we turn first to Australia, Appleby and Lemire have outlined 10 categories, which I think are really helpful for trying to get a framework for defining misconduct. They refer to conduct prior to taking office, such as abuses while acting as a lawyer, and conduct following retirement, such as perjury. And I think it's interesting that they refer not only to conduct while a judge is a judge, but also before and after they have been appointed. I accept that you can't remove a judge from office if they've already retired, but I do think it is relevant to consider conduct before a judge was appointed when assessing if judicial misconduct has occurred, especially, for example, if a judge were hearing a case where they had previously acted for one of the parties and they didn't disclose this. The other categories Lemire and Appleby refer to are bullying and incivility while in office, bias, delay in delivering judgments, administrative misconduct such as failing to regularly attend court, criminal conduct, and morally reprehensible behaviour. Due to time constraints, I don't propose to discuss all of these issues, but I will briefly draw out 3 points that I think arise from these examples. The first is that criminal conduct is relevant when considering judicial misconduct, but I don't think that conduct being criminal is in itself grounds to remove a judge. For example, a Canadian judge was found to be smoking indoors in her office. And while that could be a breach of the criminal law, I don't think that it's such serious conduct or conduct so related to her role as a judge that it would require disciplinary proceedings. In contrast, in the Irish context, we saw that Judge Brian Curtin resigned from office following allegations that he had been in possession of child pornography, which is clearly a criminal offence. Even though there was no criminal conviction in that case, due to the inadmissibility of evidence and various other factors, I do think that if a judge were to be accused of such a serious crime, that would definitely be grounds for considering if judicial misconduct had occurred. I think you can see from the examples that I've discussed and will be discussing that retirement and resignation are far more common than removal from office, which is in itself somewhat problematic. I would note that if we turn then to the English example, delay has been cited as a grounds to criticise judges and could be a potential grounds for disciplinary action. But I think it's worth comparing two different cases where judges were criticised for delay in England. Sir Timothy King of the High Court was criticised 3 times for delay, but the courts took into account the fact that he was caring for a seriously ill family member and he was himself very close to retirement. In contrast, Sir Harman was criticised for a 20-month delay in one case. But the background to those criticisms were that this judge had also been criticised for rudeness, incivility, particularly for being quite difficult with female witnesses. And I think that suggests, to my mind, that cumulative conduct can be considered when assessing if judicial misconduct has occurred. Although it's important that we don't move the goalposts on judges and that they know if they are subject to proceedings what conduct is being criticised in advance so they can prepare their defence. I do think that it could be possible for a series of misjudgments or a series of bad behaviour to result in disciplinary action, even if no one individual act would be enough on its own. For example, if a judge were to continuously smoke in their office despite criticisms and was also rude to witnesses and was also frequently late, that cumulatively could build up to creating distrust in the judiciary, which would have to be dealt with. It's also worth briefly noting that sexual harassment and bullying can be quite difficult to deal with. Professor Delahunty notes that in England, lawyers may fear making a formal complaint about judges could hinder their careers. And it's interesting that in Australia, when High Court Dyson Hayden was accused of sexual harassment, these allegations only came out after the judge had retired, and the investigation only took place after the judge had retired. So it can be quite difficult to address those issues if people are afraid to come forward with their complaints. And that's something that we need to bear in mind when considering judicial misconduct. Appleby and Lemire also give examples of morally reprehensible behaviour that they think could be grounds for judicial disciplinary action. These include frequenting a massage parlour that is known to employ sex workers, responding flippantly to reporters' comments about misconduct, discussing issues related to pending or ongoing cases, publicly criticising law reform, and publicly discussing political issues. You might add to that list allegations that a judge is in breach of COVID-19 guidelines could also fall within this category. Given that we could draw on examples from common law countries to try to flesh out the meaning of acknowledged standards of judicial conduct, I think it's worth then turning to Part B of the 2019 Act's definition of judicial misconduct, which is about bringing the administration of justice into disrepute. I think it's worth noting that Chief Justice Clark has publicly said that if there is a reasonable public perception that a judge has breached the law, this could bring the courts into disrepute, which raises the issues, I think, of what do we mean by the public and what do we mean by disrepute? Because the public, as we've seen lately, can be subject to misinformation and we cannot assume that the public have access to all of the relevant facts. The public may also be deeply divided on the issues that they are being asked to weigh in on, and the public might also change their mind as time goes on. So, to my mind, bringing the administration of justice into disrepute is the more vague element of the two-part definition of misconduct in the 2019 Act. And we see this that, for example, with the Mr. Justice Wolf controversy regarding COVID-19 and attendance at an Oireachtas golfing dinner, that judges, that the public's opinion of judges may change over time as more information becomes available, and that facts may come out in drips and drabs, which can also change the public's opinion of an event. It's worth also noting, I think, as Graham B has noted, that the public interest in complaint systems in England is very limited, and that public confidence in the Welsh and English judiciary was high even before the Constitutional Reform Act 2005, and there is no indication that reform has affected public confidence. In light of this, I think it's particularly important to have fair procedures and to have decisions that are grounded in facts and evidence when assessing whether judicial misconduct has occurred. Particularly when we are trying to define judicial misconduct in terms of bringing the administration of justice into disrepute, I think it's important that we set out what do we mean by disrepute. Thank you for listening to me today, and I look forward to seeing you at the Q&A.